This channel examines the Jeffrey Epstein case using court documents, public records, and verified reporting. We do not speculate. We do not accuse. We document what exists, and what remains unanswered. Everything presented here is drawn from publicly available sources. This is not a theory channel. This is the file. Before the private jets. Before the headlines. Before the world knew the name. There was a report. In 2005, a 14-year-old girl told her parents something disturbing. She had been paid to give a massage at the Palm Beach mansion of Jeffrey Epstein. The details didn't sound like massage therapy. They sounded like exploitation. Her parents did something simple and powerful. They went to the police. The complaint landed with the Palm Beach Police Department in Florida. At first glance, it could have been dismissed as a misunderstanding. A wealthy man, a teenage girl, a private residence, no immediate witnesses beyond the victim. But one detective didn't let it fade. Detective Joseph Carey began asking questions. What he uncovered wasn't an isolated encounter. It was a pattern. Recruiters, payments, multiple girls, similar stories. This was no longer a single allegation. It was a system. As police interviewed more teenagers, the same structure emerged again and again. A young girl recruited by a friend, brought to Epstein's home, paid cash, encouraged to bring others. Some described escalating abuse. Some were too afraid to speak fully. But the pattern was clear. Palm Beach police compiled a growing case file. By mid-2006, investigators believed they had identified dozens of potential victims. And that's when something unusual began to happen. Instead of accelerating toward prosecution, the case began to slow. Local police recommended multiple felony charges, including unlawful sexual activity with minors. But the decision to prosecute did not rest with detectives. It rested with the state attorney's office. The case was handed to State Attorney Barry Krischer. What followed would quietly transform the trajectory of justice, and nearly erase the case entirely. At the time, no national media covered it. No protests formed. No public outcry erupted. It was a local investigation involving a powerful man in a wealthy Florida enclave. And power, in Palm Beach, carried weight. What should have been a straightforward criminal prosecution began to fracture. Meetings were held. Evidence was reviewed. Prosecutorial discretion was exercised. The recommended charges were declined. Instead, the case was referred to a grand jury. That decision, technical, procedural, almost bureaucratic, would change everything. Because what emerged from the grand jury was not what detectives had built the case for. It was a single, lesser charge. The first serious case against Jeffrey Epstein had begun with urgency. It was now drifting toward something else. When the Palm Beach Police Department completed its investigation, detectives believed they had built a strong case. They had victim statements. They had corroborating accounts. They had a pattern. Detective Joseph Carey formally recommended multiple felony charges. According to police, the evidence supported serious counts involving minors, not a minor procedural offense. But the decision did not stay with the police. State Attorney Barry Krischer took the case to a grand jury in 2006. On paper, this was routine. Grand juries are used to determine whether enough evidence exists to issue an indictment. They hear testimony, review selected evidence, and decide whether charges should move forward. But there was something unusual about how this grand jury operated. Typically, prosecutors present witnesses who strengthen their case. In this instance, only one victim was called to testify, despite police identifying many more potential victims. Detectives were not invited to present the full scope of their findings directly. The broader pattern was narrowed. When the grand jury concluded, the result stunned investigators. Instead of multiple felony counts related to sexual abuse of minors, the grand jury issued a single charge: solicitation of prostitution. Not trafficking. Not sexual battery. Not unlawful sexual activity with a minor. Solicitation. To detectives who had spent months building the case, it felt like a downgrade of historic proportions. Internally, frustration grew. Some investigators believed key evidence had not been fully emphasized before the grand jury. The message was clear. The case had been reframed. A charge of solicitation carried significantly lighter consequences. It reshaped the narrative from systemic abuse of minors to a transactional vice crime. The legal exposure narrowed dramatically. And Epstein's defense team moved quickly. Instead of facing the possibility of multiple felony trials in state court, the process began shifting toward negotiation. Behind closed doors, discussions intensified. High-powered defense attorneys entered the scene. Legal maneuvering replaced investigative momentum. Meanwhile, the victims remained largely invisible to the public. There were no headlines, no national scrutiny. The case remained local, contained. But something else had changed. Federal authorities were beginning to look at the case. What the local prosecution had minimized, federal investigators viewed differently. The scope, the pattern, the age of the victims. It suggested potential federal crimes. The case that had nearly been reduced to a single state charge was about to expand again. And this time, it would enter a far more powerful arena. As the state case narrowed, pressure began building from another direction. The FBI opened its own investigation. Federal authorities were not bound by the grand jury's limited charge. They began reviewing the broader pattern that Palm Beach detectives had originally outlined: multiple minors, interstate recruitment, payments, transportation. Under federal law, this was not simply solicitation. It potentially involved sex trafficking and exploitation of minors across state lines, crimes carrying severe prison sentences. By 2007, the case had effectively shifted from a local prosecution to a federal one. And with that shift came higher stakes. The U.S. Attorney's Office for the Southern District of Florida took control of the federal review. The office was led at the time by U.S. Attorney Alexander Acosta. Federal prosecutors prepared a potential indictment. According to later reporting, a draft federal indictment reportedly included multiple serious charges involving minors. If filed, Epstein could have faced decades in prison. But before any indictment was made public, negotiations began. Epstein's legal team was no ordinary defense group. It included prominent attorneys with national reputations. They did not merely prepare for trial, they began engaging federal prosecutors directly. What followed was not a courtroom battle. It was a negotiation. Behind closed doors, attorneys exchanged proposals. Deadlines were extended, letters were sent, meetings were held. The tone shifted from prosecution to settlement. Meanwhile, the victims were not informed that federal discussions were underway. This detail would later become one of the most controversial elements of the case. Instead of filing the federal indictment, prosecutors began drafting what is known as a Non-Prosecution Agreement, an extraordinary legal tool that would reshape the outcome entirely. The potential federal case, built on dozens of victim statements, was about to be resolved without a trial. And the public still had no idea. In 2007, the federal case against Jeffrey Epstein was poised for indictment. Instead, it became a negotiation. What emerged from months of closed-door discussions was a document few outside legal circles had ever heard of: a non-prosecution agreement, often abbreviated as an NPA. On its surface, an NPA is simple. The government agrees not to bring federal charges in exchange for certain concessions from the defendant. But this agreement was anything but routine. Under the terms of the deal, federal prosecutors agreed not to pursue charges against Epstein. In exchange, Epstein would plead guilty in Florida state court to two state-level offenses: solicitation of prostitution and solicitation of a minor for prostitution. The distinction was critical. He would not plead guilty to federal sex trafficking charges. He would not face a federal trial. He would not risk decades in federal prison. Instead, the federal case disappeared. But the most controversial provision was buried deeper in the document. The agreement extended protection beyond Epstein himself. It granted immunity to potential co-conspirators, unnamed individuals who might otherwise have faced investigation or indictment. Their identities were not disclosed publicly. This clause effectively shut down federal exposure not just for Epstein, but for others connected to him. Equally significant was what did not happen. The victims were not notified of the agreement before it was finalized. Under federal law, specifically the Crime Victims' Rights Act, victims are supposed to be informed and consulted during plea negotiations. That did not occur. The agreement was signed quietly in September 2007. No press conference. No national announcement. No public explanation of why federal charges were being dropped. Instead, the case returned to Florida State Court. In 2008, Epstein pleaded guilty to the reduced state charges and was sentenced to 18 months in jail, a sentence that would later become the focus of intense scrutiny. What had begun as a federal investigation with the potential for life-altering prison time had been converted into a state plea deal with limited consequences. To the public, the case barely registered. To the victims, it felt like it had vanished. In June 2008, Jeffrey Epstein stood in a Florida courtroom and entered a guilty plea. The charges were state-level offenses: solicitation of prostitution, solicitation of a minor for prostitution. No federal sex trafficking charges. No sweeping indictment. No public trial. He was sentenced to 18 months in the Palm Beach County Jail. On paper, that sentence appeared significant. In practice, it was anything but typical. Within weeks, Epstein was granted access to what was called a work release program. This allowed him to leave jail for extended hours, 6 days a week, to work at his private office. He was permitted to leave the facility for up to 12 hours a day, unescorted. He returned to jail at night. Reports later indicated that deputies were paid by Epstein to provide security during his release hours. The arrangement raised immediate questions. How common was this level of flexibility? Who approved it? What criteria were applied? For many observers, the optics were unmistakable. An individual who had admitted to soliciting a minor was serving a sentence that looked unlike the experience of ordinary defendants. The contrast deepened when compared to standard outcomes in similar cases. In many jurisdictions, sex crimes involving minors carry multi-year, often multi-decade, prison terms, particularly when patterns of behavior are documented. Yet Epstein's incarceration became a hybrid, part jail term, part structured freedom. He ultimately served approximately 13 months before being released in 2009, accounting for time reductions. But the legal consequences did not end there. He was required to register as a sex offender. Still, the broader system that had once appeared poised to dismantle him had instead produced a limited conviction and a controversial sentence. National attention remained muted. The case had not fully disappeared, but it had been contained. That containment would last for nearly a decade. Until investigative reporting reopened everything. For nearly a decade, the case remained largely dormant in the national conversation. Jeffrey Epstein returned to a version of private life. He maintained residences in multiple cities. He continued moving in elite social circles. For many outside Palm Beach, his conviction was barely known. But unresolved questions lingered. Why had federal charges been dropped? Why were victims not notified? Why did the agreement include immunity for unnamed co-conspirators? In 2018, investigative journalists began revisiting the case in detail. Through public records, court filings, and interviews with victims, reporters reconstructed the timeline of negotiations that had taken place behind closed doors. The findings were explosive. Documents revealed the existence of the federal Non-Prosecution Agreement. Internal correspondence showed prolonged negotiations between Epstein's legal team and federal prosecutors. Most significantly, it became clear that victims had not been informed of the deal before it was finalized. The story reignited national scrutiny. Public pressure intensified. Lawmakers demanded explanations. Legal scholars questioned whether the Crime Victims' Rights Act had been violated. In 2019, a federal judge ruled that the government had indeed violated victims' rights by failing to notify them during the plea negotiations. While the ruling did not void the agreement, it formally acknowledged that the process had bypassed required protections. The case that had nearly vanished was now back in the spotlight, not just as a criminal matter, but as a procedural failure. Soon after, federal prosecutors in New York took action. In July 2019, Jeffrey Epstein was arrested on new federal charges related to sex trafficking of minors. The system that had once stepped back was now stepping forward again. But history would take another unexpected turn. On July 6, 2019, federal agents arrested Jeffrey Epstein at Teterboro Airport in New Jersey. This time, the charges came from the U.S. Attorney's Office for the Southern District of New York. They were not minor. They included sex trafficking of minors and conspiracy, federal crimes carrying potential sentences of decades in prison. The indictment described a pattern that echoed the earlier Florida investigation: recruitment of teenage girls, cash payments, exploitation within private residences. But this time, the case would proceed in federal court in Manhattan. Epstein was denied bail. Prosecutors argued he posed a flight risk, citing his wealth, international connections, and access to private aircraft. The court agreed. He was remanded to the Metropolitan Correctional Center in New York City. Inside the facility, events quickly grew complicated. In late July 2019, Epstein was found injured in his cell. Officials initially described it as a possible suicide attempt. He was placed on suicide watch, then later removed from it. On August 10, 2019, less than 6 weeks after his arrest, Epstein was found unresponsive in his cell. He was pronounced dead shortly thereafter. The official ruling: suicide by hanging. The timing shocked the public. The case that had nearly disappeared once before had re-emerged with full national attention, only to be abruptly halted again. Security failures were documented. Cameras malfunctioned. Guards reportedly fell asleep. Standard monitoring procedures were not followed. For many, the circumstances felt incomprehensible. Epstein's death immediately triggered widespread speculation. Conspiracy theories flourished. Political figures across ideological lines questioned how such a high-profile detainee could die while awaiting trial. The criminal case against him was formally dismissed weeks later due to his death. There would be no federal trial. No full public accounting in court. The first case had almost disappeared quietly in 2008. The second ended suddenly in 2019. But the legal story was not over. Jeffrey Epstein's death ended the criminal case against him. But it did not end the legal process. In the absence of a federal trial, survivors turned to civil court. Civil litigation operates differently than criminal prosecution. The burden of proof is lower. The objective is financial accountability rather than imprisonment. And most importantly, it allows victims to continue pursuing claims even after a defendant has died. Almost immediately, lawsuits were filed against Epstein's estate. The estate, reportedly valued in the hundreds of millions of dollars, became the central legal battleground. Executors were appointed. Claims were reviewed. Negotiations began. Under mounting pressure, the estate established a compensation program designed to settle claims outside prolonged courtroom battles. Survivors could submit documentation and testimony in exchange for financial settlements. For many, it was a difficult choice: pursue a public trial against a powerful estate, or accept compensation and closure through a structured process. At the same time, attention expanded beyond Epstein himself. Civil suits began targeting individuals and institutions alleged to have enabled, facilitated, or ignored the abuse. Financial institutions faced scrutiny for processing transactions. Associates faced accusations of participation or complicity. One of the most prominent legal developments involved Ghislaine Maxwell, a longtime associate of Epstein. Unlike Epstein, she faced criminal prosecution. In 2021, Maxwell was convicted in federal court on charges related to sex trafficking of minors and conspiracy. She was later sentenced to 20 years in prison. Her conviction marked a rare instance of direct accountability connected to Epstein's network. Meanwhile, litigation against financial institutions continued, focusing on questions of due diligence and red flags. Internal communications, compliance failures, and risk assessments became part of the public record. The civil phase did something the original 2008 case had not. It exposed documentation, emails, financial records, corporate decision-making processes. Even without a criminal trial for Epstein himself, the broader system was now under examination. But one final question remained. How did the first case nearly disappear in the first place? And what does that reveal about prosecutorial discretion, power, and influence? When people ask how the first case nearly disappeared, they often look for a single dramatic explanation. A secret phone call, a hidden directive, a powerful intervention. But what the record shows is something more subtle, and arguably more unsettling. The case did not vanish because of one decision. It faded through a sequence of institutional choices. First, prosecutors narrowed the scope of the grand jury presentation. Then, federal authorities entered negotiations rather than filing indictment. Then, the Non-Prosecution Agreement was structured broadly and quietly. Then, victims were not informed before the agreement was finalized. Then, the sentence was arranged with unusual flexibility. At each stage, discretion was exercised. Prosecutorial discretion is a legitimate and powerful tool. It allows the government to weigh evidence, resources, and the likelihood of conviction. Plea agreements are common in the American legal system. But discretion becomes controversial when outcomes diverge sharply from typical patterns. In Epstein's case, local detectives believed they had evidence supporting serious felony charges. Federal prosecutors reportedly prepared draft indictments. Yet the final resolution reduced exposure dramatically. No public trial tested the evidence. No jury heard the full scope of testimony. No cross-examination played out in open court. Instead, the most consequential decisions occurred in private negotiations. And privacy, in this context, was decisive. The legal system often operates through negotiated settlements, but those negotiations usually happen in the shadow of potential public scrutiny. Here, scrutiny came years later. When investigative journalists uncovered the Non-Prosecution Agreement in 2018, many observers were not shocked that a plea deal existed. They were shocked by its breadth, particularly the immunity granted to unnamed co-conspirators and the exclusion of victims from the process. The institutional pattern reveals something important. The system did not collapse. It functioned, but in a way that shielded rather than exposed. No law explicitly required the broad immunity clause. No law required such a narrow grand jury presentation. No law required extended work release conditions. But each decision was legally possible. And together, they reshaped the outcome. By the time the public fully understood what had happened, nearly a decade had passed. The first case had not disappeared through force. It had dissolved through procedure. Looking back at the first case against Jeffrey Epstein, one fact is undeniable: it almost disappeared. Not because of evidence failure. Not because victims were dishonest. Not because the law didn't exist. It disappeared because the system allowed it. Institutional discretion, procedural choices, and the quiet power of negotiation reshaped the case. A grand jury presentation narrowed. Federal charges were dropped in exchange for a non-prosecution agreement. Victims were left uninformed. Sentencing arrangements were unusually lenient. Each choice was lawful, but collectively, they produced a nearly invisible outcome. Jeffrey Epstein avoided the full weight of justice for years. The first investigation faded, leaving victims without accountability and the public largely unaware. What can we learn? First, power matters. Wealth, influence, and social proximity can affect how cases are handled, which evidence is prioritized, and which charges are pursued. Second, process matters. Legal discretion and procedural tools, while necessary for a functioning justice system, can also conceal systemic failures when applied without transparency. Third, history matters. Investigative reporting years later revealed what had happened. Documentation, emails, and civil filings brought the hidden story to light. But until someone scrutinized the system, the case might have remained invisible forever. Finally, justice is more than punishment. The first case's near disappearance highlights the importance of victims' rights, oversight, and public accountability. Legal mechanisms can be misused, intentionally or not, to protect defendants while minimizing the visibility of crimes. The first case against Epstein is not just a story about one man. It is a cautionary tale about the institutions around him. About how discretion, secrecy, and power can combine to let even the most serious allegations slip through the cracks. And while later arrests, lawsuits, and convictions partially corrected the record, the first case remains a haunting reminder. Sometimes, justice doesn't fail because the law is weak. It fails because the system, step by step, allows it to. The story of the first case that almost disappeared is now part of the public record. But its lessons about power, accountability, and institutional choice will resonate far longer than any headlines. The documents exist. The questions remain. This channel will continue examining what is public, and what is still hidden. If you value documented analysis over speculation, consider subscribing. More files coming.